I'm standing outside the arbitration room. The employee's wife suddenly takes out her phone and snaps a photo of me with my ear against the door. A few minutes later, the lawyer explodes inside the hearing. But to understand why this became the turning point of a 1-year CCMA case, we need to go back.
Chaile time.
Morning and welcome to this week's edition of It is Chaile Time, and the title today is How an Aggressive Lawyer Crashed His Own CCMA Case. How an aggressive lawyer crashed his own CCMA case. You know, when it comes to litigation or dispute resolution, especially when it goes to CCMA or the labor courts, a case will typically be so emotive. There's so many emotions involved in this case, and there's this deep sense of injustice incurred by either party, or the one party will feel that the other person was unreasonable or really committed an injustice to the person itself, that we often resort to a feeling of, I must get myself a no-nonsense lawyer. You know, these lawyers that are so aggressive, you know, they assertive, they are emotional, you know. Regardless of the actual merits of the case, often it happens that the lawyers won't really necessarily tell you the full scope of the case, the path of litigation, or whether you really have merits or not. And I'm not saying that is always the case. Obviously, I'm not saying that. But one sometimes get the sense that an aggressive lawyer, those no-nonsense kind of lawyers, they often have blind spots. Blind spots that can actually crash your case. So there's a saying, some CCMA cases are won on evidence. Others are lost because somebody stopped thinking strategically. Let that sink in for a moment. I was involved in a CCMA case in one of the coastal regions for the last year. It's a case that the employee resigned on the 30th of May. It's almost the 30th of May again the following year. So this whole case, this whole dispute took about a year. In this case, I was actually the main witness for the employer. Our company provides HR services to this company, so I was heavily involved in terms of the merits, in terms of what happened here. And we appointed a representative, a lady, to represent the employer. I was then the main witness. There was another 2 witnesses then also from our side involved in this case. The employee took the services of an attorney. Man, what a force to be reckoned with. A very aggressive kind of attorney. He's a kind of attorney that he really imposes himself, even to the extent where occasionally it will look like he wants to get onto the table, you know, something like this, you know. So he really tries to dominate, he tries to influence, you know. I have also represented employees in my life, and sometimes you get the sense that, you know, if there's no case for the employee, then you need to show some aggression just for the employee to feel he got some value for his money. But be that as it may, so let's just go back quickly and explain what this case is, what happened, what it's all about. So, this employee was a manager, a branch manager. We were the HR support service to him also and to the company. So we, for instance, typically will have, as a fast way of communication, have a WhatsApp group with me and some key staff on my side on the WhatsApp groups. And when a manager needs assistance, advice, need to consult, need assistance with disciplinary matters or dealing with grievances or whatever the case may be, then this manager will typically then, ask for such assistance on the WhatsApp group. But he never actually complained about any issues with the employer itself. There was one outstanding issue when he was employed. This was a new branch opening, and there was a bit of a debate in terms of the starting date of his employment with the company. There's like a disagreement of a period of about 3 months. That is the issue. So all the staff eventually signed their contracts. I assisted the staff, but this manager never signed his contract. Okay, because of this one issue, he's disputing the starting date. It had no material impact on his employment. His remuneration was always paid on time. There's never been an issue. He never actually formally lodged any grievances or even raised the dispute that he had with the owner of the business or any other staff in terms of, injustices caused to himself, in his person. So during his roughly, he was employed for about a year or so also. I had various engagements with him to ask him, what about your contract? Are you going to sign? And to explain to him the situation, around why there's this discrepancy, which actually makes quite sense. I'm not going to go into detail on that. He eventually then told me, he's fine with that. He will sign the contract, but he never did. But yes, is now the thing. May last year, I went to have a meeting with a business owner at another branch, and lo and behold, the manager of this branch also happened to be there. He also just arrived, so basically myself and him arrived at the same time. I met him outside. I greeted him and asked him what the purpose of his attendance is here. And he was actually not part of the meeting that I was called in for. He was actually there to apply for leave because he wants to go visit a family member in South America somewhere. I think it's his mom or his aunt or somebody like that. So that is why I was there. So I had a meeting with the owner, and we were just speaking general HR issues, and one of the issues we spoke about is disciplinary matters, outstanding disciplinary matters. And yes, the topic of his unsigned contract arose, and so we spoke about this, and then because he was there, he was called in, so it was myself, the owner, and another manager sitting there, and we spoke about his contract and the issues, and yes, there was a bit of a debate in terms of the reason for the discrepancy, in terms of his starting date. The debate was a bit heated. It was not a lot, really. There was no swearing, there was no cursing, nothing like that. But it was a meeting of, can we get this now done? What is the issue? At the next moment, he says he wants to resign. So we all were shocked. We're like, what? I mean, this is not the this is not even on the cards. I mean, this is not even. Not wanting, he was doing a good job. There was no problems with his performance. I mean, it was a new branch. He's the manager. He did a good job. There was no issues there. We just want the contract to be signed. So then he's adamant. No, he's leaving. He wants to resign and leave now. So I took out a piece of paper, tear it out, give him a pen, and give him a piece of paper, and say, well, if you are feeling so strong about this, we're not going to stop you. So then. Write your resignation letter. He then told me, but listen, he can't write in English. Strange. Anyway, so he asked me then, can I write it for him? So I did write it for him. But there were spaces that I left blank on the top and at the bottom where he can, with his own handwriting, write in his own name and surname, and also at the bottom again write his own name and surname, and then he also signs. That happened, and he left. Okay, he went to the CCMA and he filed a constructive dismissal dispute. That's right. Okay, so it is my professional opinion there was no merits if you take recent case laws into consideration, where it basically states that an employer must make an employment relationship intolerable, and they have to be like oppressive before a constructive dismissal claim may succeed. For those of you who don't know, for a constructive dismissal claim to succeed, there must be 3 elements that is relevant. The one is there must be a resignation. So this is what happened. He did resign. Secondly, the employment relationship must have become intolerable. Now that is a very, very high threshold. That is not because your boss forgot to make you a cup of coffee in the morning, you know. And thirdly, the party that is responsible for creating the intolerability must be the employer. It can't be your colleague per se, you see. So, constructive dismissal case. So he got himself this fancy lawyer, aggressive lawyer. We eventually started off obviously with, there's a con-arb process. We objected against con-arb. There was conciliation. Now, the employer proposed to settle the matter on 15,000 rand. We didn't believe he had merits. Okay, I mean, this was completely his own doing. Anyway, the employer was willing to settle on 15,000 rand. He was not willing. He wanted much more, which was really unacceptable at this stage. Now, you can understand already, if you are an employee and you get yourself a lawyer involved, obviously the lawyer wants money, so he wants to be paid. So, and this is why it is sometimes so unfortunate that you as a party to a dispute, you are dependent on your litigant, or your lawyer, your representative. And because you have their interest now in this mix, sometimes you are the biggest loser yourself, it's purely because you now have to pay the attorney. Now, on that note, quickly, when I, for instance, represent a company on an ad hoc basis who don't have a retainer, every single time I will tell the company, listen, let's put down a certain amount of money to settle, because what I'm doing is I'm transferring my fees. I'm giving up my fees. I'm saying, listen, arbitration can take a long time. It can take months. I'm involved in cases that took over 2 years now, okay? And I will say, listen, give the guy the 20 or the 30,000 rand or whatever the case may be. I'm really giving up my fees. So that is my approach. I really try to help my client, okay? But it's not always the case. So, okay, the employee didn't accept the 15,000 rand. So then eventually arbitration. But there was quite a few set-downs in arbitration. So, we were advised, or there was a ruling by the commissioner that we need to do a pre-op and then do the pre-op minutes. So myself and the attorney and my representative, we actually met with the attorney. We had the pre-op meeting, and then he needs to submit the pre-op minutes. And as you know, there are a time limit as to when a pre-op minute must be submitted to the commissioner. And he missed the timeline, the deadline. So he was late in filing the pre-op minutes. And 2 days, more or less 2-3 days before the actual the arbitration, this was a couple of months ago. Probably about 5 months ago, I'll say. 2-3 days before the arbitration set down, he phoned me, panicking, asking me if his client didn't pay him, and they only paid him now, and he doesn't do work if he doesn't get paid. Okay, if I won't mind if we agree to submit the pre-op minutes late. For me personally, I know how it goes by the CCMA. I know there are timelines, but when it comes to the submissions of pre-op, I've never seen that the commissioner really have a problem if you submit the pre-op minutes late. I mean, if you submit it even on the day, they don't normally mind, even though, there are deadlines in terms of the CCMA rules. It's actually a non-issue. So I just told him, listen, it's a non-issue. I don't have a problem. Let's just sign it and get it done with. Even if we submit it on the day, no problem there. So he was nice and kind to me. I was nice and kind to him. But then came the set down. So we actually, the day of the hearing. So this was now, when was this? This was now, a few months ago. So I'm the main witness of the company. So in a constructive dismissal case, okay, so the employee must go first. With normal dismissal disputes, it's always the employer party going first, but with constructive dismissal cases, the employee party going first. They must prove those 3 elements, of course. But it took quite a long time. And, at some stage, I got up and I went to put my ear against the door. It was probably 30 seconds. I wanted to gauge where in the process we are. Now, there's only one lady in the room. The rest are all male, okay? So, yeah, I couldn't hear detail through the door. Obviously, you can't hear detail, okay? I don't have super hearing. I'm not an X-Men or something like that. But anyway, I could hear at that stage that a woman was talking. So I presumed that, okay, we probably were busy with cross-examination the employee, because otherwise, she wouldn't have been doing the talking. That was it. It was about 30 seconds. But down the passageway behind me, the employee's wife was there just to support him, and she took a photo of me on her phone with my ear against the door. It was a few minutes later. Cross-examination was done, and now it was the employer's turn to start, and I was the first and the main witness. So I went in, and suddenly this lawyer exploded. Sure. And he had an issue, and he accused me of listening in and filtering information through to the company. And I'm like, yes, this is a bit far-fetched, okay? And he demanded that I be recused, that I be denied the right to testify. I mean, suddenly this whole thing just explodes. But now he's this character also, getting on the table and shouting and demanding, From our side, since the first day we recognize this personality, we become strategic. It's very important to think on your feet, to calm down, because this character of attorney typically have blind spots. The emotions is getting the best of them, and they don't always think strategically. For them it's about the theater, about the show, about influencing the commissioner and try to dominate. Even when we talk, no, he wants to make you quiet. You can't talk now. I'm busy talking. So that kind of person don't even want to give you an opportunity to talk. Actually, I forgot to say this. Right in the beginning, in the first arbitration session, just before we started, that meeting was also adjourned. I can't remember why it was adjourned. But I then, so the commissioner will ask us quickly what's the case is about, and then the lawyer made some allegations, and I simply looked him in his face. But of course, I could discern this personality. I looked him in his eyes and told him in his face he's a liar. But that was just to unsettle him. And also, I was just showing the employee, he mustn't think that he can hide behind that personality of a lawyer. Yeah, like that guy exploded. He didn't appreciate that I told him he's a liar, But yeah, so you become very strategic with this kind of personality. So here he is in the arbitration, shouting and demanding I be recused. And I just thought to myself, Toby, what did you do? I mean, I know how it looks like, okay? But anyway, so we were thinking on it. I knew that, listen, there's issues between him and the client. And I thought to myself, you know what? This is potentially a complicated matter. This whole issue now with him objecting against me testifying. So I asked the commissioner, listen, can we please adjourn so we can seek legal counsel ourselves? I just felt we had the right to do that. And then he can submit a formal application in terms of what his issues are. And then we will rebut those issues on papers. And then the commissioner then agreed and said, yeah, then he will make a decision on the papers as to whether to allow me or not. I didn't think that there will be an issue because there was nothing to this really. But anyway, then obviously he exploded even further, demanded that we recuse me right now and we continue with the case. Had we continued with the case right there and then, that case would have been dealt with in its entirety on that day, and there would actually have been a result. But now the matter got adjourned. Now you have on the one hand an aggressive lawyer. On the other hand, you have a patient, strategic representative. My representative was fantastic. And in the middle, you have the commissioner between all of this drama. So this matter was adjourned. And I just thought to myself, big mistake. So the commissioner gave us a certain date as a deadline as to when the submissions by the applicant's attorney must be in. They never met it. They never submitted the application. And yesterday, the case sat down again, and they did not pitch. The employee and his attorney didn't pitch, so the case actually got dismissed. This is now after a year. The case got dismissed. The employee is walking out with bills that he had to pay. He could have settled this dispute on 15,000 Rand right in the beginning already. And I was thinking about this, and I'm like, yes, if I was that attorney, I would have also been concerned. Obviously, I would have been. But you also need to counsel your client to say, listen, this is either an issue or it is not an issue. Let's not make an issue of something that's not an issue, so that we don't have to come back again and you have to keep on fitting the bill. You see, I would have addressed the matter, sure, in a calm and respectful way. I would have listened to what I have to say, and I've told you there's only a 30-minute, I was there only for about 30 seconds. Interesting is the author of the video, the wife, didn't take a video because she knew I was there for a brief moment. It's much more convenient to take a photo and then add a tail to the story, isn't it? And I would have left it at that. And let us continue and finish the case in the best interest of my client. That was not the case. So this is a classical example at the end of the day. The real loser here was a client who sat with an aggressive lawyer filled with emotion. That's the real loser at the end of the day. I don't think the client would have won the case, but that's not the point. The point is, he could have gone through the entire case and actually had a result, but he was deprived of that. So, I think the main message, if you're a party to a dispute, if you're an employee or an employer, you must also take responsibility, okay? In terms of this case, first of all, I've always said this, that the fact that you have a right to go to the CCMA doesn't mean you must exercise those rights, because arbitration is with prejudice. You mustn't always exercise it. So you need to know when to fight and when not to fight, okay? If you do decide to fight, you must also be involved. You must also ask questions. You must also think, and you must look at your lawyer, your representative. Is this a guy that's just bashing for money? Or is this a guy that's really serving your interest? I mean, I've had discussions with CCMA commissioners where they told me they will sit in arbitration and then there's a lawyer who's got evidence behind the desk, behind the table, that can win a case, but they don't submit it. Why? So that the matter can go and review at the labor court so they can get more money. Okay? So, once again, as a party to a dispute, don't just give it to your lawyer and that's it. I understand that you are depending on them for legal advice, but you must have some discernment too. Is this guy in it for the money, or is this guy really there to serve my interest? That is it for this week. How an aggressive lawyer crashed his own case. Now we have jobs review, fresh vacancies placed on our Harmony People Network. And yes, if you have not registered yet for the Harmony People Network conference, 10 September 2026 at the Kiewitzkroon Wine Estate, do so now. Bye-bye.
Good morning, everyone. Let's have a look at some of the vacancies posted nationwide on our Harmony People's Network this week. First up, a global specialty and branded pharmaceutical company is seeking a sourcing specialist who is directly responsible for working with the external co-manufacturing network to identify, source, and deliver products to support the company's growth in new product innovation, as well as to ensure our existing supply portfolio has supply continuity. Verican Outsourcing is looking for an experienced payroll manager to take ownership of the end-to-end payroll function for a large and complex workforce. Effectus Harmony is also looking for a motivated and professional HR consultant to become part of our growing team, and Wembro Construction Equipment is hiring an HR supervisor. For the full information of the mentioned positions, how to apply, as well as more available positions, find the vacancy link in the description. You will also find a link to a useful video on how to compose a winning CV and have a successful interview. Tune in again next week for more Harmony vacancies.